rise. 72nd District mock trial is now in session.
On behalf of my fellow judges, thank you very much, and please be seated. The court calls the Circuit Court for the County of Superior to order. I am Judge David Nicholson. I was advised that I need to give a short bio, and I will also have the other judges do that. I graduated from Port Huron High School in 1959, Port Huron Junior College in 1961, and Wayne State University in 1963. I graduated from Wayne State University Law School with a Juris Doctorate in 1966 and was admitted to practice in that same year. Practiced in Detroit for a couple of years, and then in Macomb County for a year and a half, and then moved back to Port Huron. I was in a law firm here in town for many years and was appointed to the district court in October of 1994, and I retired just this past January, and I am now in retired status. At this point, I would introduce you to Judge S. Keith Bankson, Jr., who will give a short bio of himself.
I'm a long-time Port Huron person. I graduated from Port Huron High School a year behind this guy. I'm a long-time lawyer in Port Huron, and now I'm a district court magistrate.
And I would introduce Judge Timothy Cook.
My name is Tim Cook. I'm a magistrate and the district court administrator for the 72nd District Court. I've been employed with the county for approximately 20 years. It's nice to have you all here.
And John Corey.
Good morning, my name is John Corey. I'm an attorney here in private practice in town. I've been an attorney since 1979, and I'm looking forward to hearing your trial here.
Thank you. This is round one of the St. Clair County mock trial tournament. By rule, the participating schools are not to be identified. The purpose of this tournament is multifaceted. It is educational. The youngsters that have been dealing in this program have, I am sure, gained a lot of education in this program at this point. It is also competition, very keen competition, we hope, and first and foremost, it is to be fun. It is to be enjoyable by the people that are involved, so don't get all stressed out about things. We will try to make this as enjoyable as possible. We are trying the case of Evan Brooks plaintiff versus Shannon Lawrence and the City of Clearwater Police Department. Are the parties ready to proceed?
Yes, Your Honor.
That's
Yes,
right.
Your Honor.
Right. At this time, I would ask each of the attorneys for the plaintiff to place their appearance on the record.
Good morning, Your Honorable Judge Nicholson. My name is James Hagel, and I will be directly examining Devin Brown as portrayed by Evan Brooks as portrayed by Devin Brown. My co-counsel will consist of Nicole Glass and Chuck Tinker, and I will be cross-examining Officer Shannon Lawrence.
Right.
Hello, I am Charles Tinker. I will be directly examining Dana Derecha, played by Ashley Davidson, and cross-examining Alex Camp.
Good morning, Your Honor. My name is Nicole Glass. I will be directly examining Dr. Whitney Taylor as portrayed by Joshua Guild, and I will be cross-examining Officer Rodriguez.
Thank you. For the defense.
Good morning, Your Honor. I'm Travis Washington, and I will be directing Devin Rodriguez, what's portrayed by Jeremy Barnum, and crossing Evan Brooks.
Good morning, Your Honor. My name is Kevin Johnson. I will be direct examining Alex Camp as portrayed by Josh Wilson, and I will be cross-examining Dana Dreck.
Good morning, Your Honor. I am Cassie Dienda, and I will be directing Shannon Lawrence, played by Amanda Thornton, and I will be cross-examining Dr. Whitney Taylor.
Thank you. I would admonish all participants, indicating that you are to be held to the rules that you've all been made aware, including time limitations which will be strictly adhered to. This is an intentional tort case alleging personal injury and intentional infliction of emotional distress, which allegations have been denied. Are there any matters to come before the court prior to opening statements by plaintiff?
Yes, Your Honor. On behalf of the plaintiff, we would like to make a motion of limine to preclude the defense from introducing any evidence pertaining to either the in-school suspension of Evan Brooks or also the charges and dismissal of charges pertaining to this case that she received. The only reason for the defense to bring this into evidence would be to draw undue probative value to facts that have no bearing on whether or not Officer Lawrence has obligation to obtain, to desist from engaging in excessive force. Thank you, Your Honor.
Okay, who from the defense wishes to respond to that motion?
I will, Your Honor. The suspension of Evan Brooks brings up his past behavior and his just what he does. Like he has patterns of behavior, and it's not an old thing. It's recent. So we ask that be still allowed to be entered into the case. Just a suspension.
All right. Because of the fact that it may have a tendency to bear on his credibility, I think that it can be allowed. I would indicate that it cannot be allowed for purposes of arguing that this was past conduct that was repeated, or similar conduct that was conduct similar to that which occurred, and if it occurred before, it's likely to have occurred this time. It may not be used for that purpose. And with that understanding, it may be used if appropriately used in impeachment.
Thank you, Your Honor.
All right.
And
anything else?
yes, the defense would like to make a motion of eliminate or that all of Officer Lawrence's personal records be inadmissible to this case because it is a bad character evidence and is irrelevant to the incident that happened in Chapel on the night of October 26, 2006.
All right. May I respond?
Your Honor, both complaints in Defendant Lawrence's file are indicative of his volatile behavior, specifically the incident in 2002 in which he was given a warning. Therefore, it says that in his acting in his official duty, he has in the past twice been known to act this way. It shows that he, as a police officer, does not have the proper self-control in order to perform properly in these situations.
Counsel, it's interesting, just a moment, Mr. Johnson, or Washington, I'm sorry. It's interesting that you would make the motion on behalf of the plaintiff to stop that sort of information coming in regarding one of your witnesses, but want to use it in the other direction. And it seems to me to be incongruent for you to take both sides of that same issue and argue them differently.
We feel that in his official duty, he has more of an obligation to perform in such ways than the average citizen, Your Honor.
All right, counsel?
We feel that Officer Lawrence's records are out of date because the complaints happened over 4 years ago and therefore are irrelevant to this case.
All right. I think that in order to be consistent, that we need to rule in the same way here, that that his prior conduct may go to his credibility, but that it may not be argued that his past conduct is indicative in any way of his conduct on this particular occasion, and should not be argued in that fashion. All right, any other matters to come before the court?
No, Your Honor.
All right, at this point, we will have an opening statement by the plaintiff.
Good morning, and again, my name is James Hagel. May it please the court and members of the jury that along with my co-counsel, we represent the plaintiff, Evan Brooks. Today, you will hear a classic case of abusing power, of an individual using needless force on a young 19-year-old woman who was simply just trying to complete her shopping at the shop hall location. Throughout this trial, you will frequently hear the names of several people. First, there is my client, Evan Brooks. You will hear that at the time of this ordeal, Evan was only 19 and a senior in high school, and was a very, very well student, involved in extracurricular activities such as mock trial and spirit team. On the night of October 26, 2006, Miss Brooks will tell you how she was shopping at the shop hall before leaving to Florida to be with her sister at her older sister's wedding. Another individual you hear today a great deal about is the head cashier, Dana DeRecha. Ms. DeRecha was the only other person besides the parties to witness this action, that actually witnessed the attack by the defendant on my client. Of course, there are the defendants in this case, Officer Lawrence and his employers, the Clearwater Police Department. You will hear testimony how the local police department had active knowledge problems with police brutality, and that defendant Lawrence had been written up 2 times with prior complaints of excessive force. These are just some of the individuals that you will constantly hear about throughout this case. Ladies and gentlemen, what happened that night this tragedy occurred? The evidence will clearly show that the defendant, Officer Lawrence, threatened my client by first telling her that he was going to fix her. Then she acted out these threats by first shoving her onto a conveyor belt without warning at the cash register. Then she shoved her into a glass case with so much force that the glass case broke and cut Miss Brooks. Finally, he forcefully handcuffed her. As if all of this wasn't bad enough, the defendant directed 7 of his fellow officers to arrest Miss Brooks for alleged disorderly conduct and trespassing. That's it, Your Honor.
All right. Does the defense wish to give an opening statement now, or to...
We'd like to give it now, Your Honor.
Pardon me?
We would like to give it now.
All right, you may proceed.
Good morning, Your Honor, gentlemen of the jury. If it may please the court, my name is Kevin Johnson, alongside Travis Washington and Cassie DeAnda. Today, the plaintiffs have the burden of proof. They must prove 3 elements today by a preponderance of the evidence: battery, false arrest, and intentional infliction of emotional distress. This case today involves an emotionally challenged teenager whose lack of respect for authority got her into a hole that she couldn't get herself out of. Shannon Lawrence, being the law-abiding officer she is, tried to give the young woman several opportunities to leave the store to avoid any further confrontation, as if she were trying to lend a hand so she wouldn't dig herself any deeper. You will hear witness testimony today from Dana DeRecha, the shop hall cashier, who will tell you that she wasn't paying her fullest attention to the surroundings like a responsible cashier should have. You will also hear from Alex Camp, the shop hall manager, who was fully aware of his surroundings and did his job in calling the police at the first sight of a struggle. Obviously, you can't believe someone who likes to daydream on the job and is not fully aware of what is going on in the store that she hopes to manage in the future. According to Dana Dreca, the store she hopes, According to Dana Dreca, Shannon Lawrence went outside her legal boundaries in handling Brooks. Gentlemen, we are not disputing that she intentionally restrained Brooks or that there was harm done to Brooks. But when someone struggles with an arresting officer, someone is bound to get hurt. But in ignoring Officer Lawrence's verbal direction, it gave Officer Lawrence the legal justification to restrain Brooks by any means necessary. Then comes the false arrest charge, which is when someone restrains another without consent and without legal justification. Today, you will hear witness testimony from Devin Rodriguez, the Clearwater Chief of Police. Devin will tell you when someone is an officer of the law, they are to enforce it at all times, which is exactly what Officer Lawrence did with Evan Brooks. Officer Lawrence did restrain Evan Brooks without consent. No one would ever consent to being arrested. But once Evan Brooks was in the store after closing time, Officer Lawrence had every legal justification to arrest Brooks for trespassing and any other law that Lawrence suspected Brooks of disobeying. Finally, the charge of intentional infliction of emotional distress, which is when someone recklessly engages in extreme and outrageous conduct that intends to cause severe and emotional distress to another. Gentlemen, there was nothing extreme or outrageous about this incident. Evan Brooks was already emotionally disturbed. You will hear witness testimony from an expert today, Dr. Whitney Taylor, who will tell you about how Evan Brooks suffered from severe emotional problems as well as background information on her problems with authority figures. If Evan Brooks would have simply followed the orders of Shannon Lawrence, none of this would have happened. Officer Lawrence was simply doing the job she was taught to do as a security guard at Shop Hall and highly trained police officer of the Clearwater Police Department. You hear witness testimony from Officer Lawrence herself, who will tell you Evan Brooks threatened her and how Evan Brooks responded violently to the simple gesture to leave the store peacefully. Let Evan Brooks dig herself out of this hole today. Find Shannon Lawrence and the Clearwater Police Department not guilty of all these charges. Thank you.
You may call your first witness.
Your Honor, we call Evan Brooks to the stand.
Please raise your right hand. You swear to abide by all of the rules of the 72nd District Court of trial.
Proceed, please. State your name and spell your last name.
Evan Brooks, Brooks.
You may proceed.
Miss Brooks, where do you reside?
3454 Southeast Clearwater.
And how old are you?
I am 19.
And what school do you attend?
Clearwater High School.
Do you participate in any school activities?
Yes, I do. The mock trial program and Spirit Squad.
What did you do the night of October 26, 2006?
The night of October 26, I hurried to the shop hall before they closed to pick up some last-minute items for my sister's wedding.
What were your intentions at the shop hall?
I just needed to pick up my last-minute items because I was leaving on a flight that next morning, actually.
When you were done shopping, what did you do?
I went to the only cash register that was open, actually, and started to put my things on the conveyor belt.
Had you forgotten anything?
I had forgotten my deodorant, actually, and then that was when I asked the cashier if I could go back to get it.
Did you go back to get the deodorant?
Yes, I did. The cashier told me it was in aisle 1.
Did you take your cart and other items to go with you?
No, I left my items on the conveyor belt, and I left my cart in the aisle.
What happened when you went back to get the deodorant?
When I went back to get the deodorant, I was confronted by the defendant who told me I needed to leave the store immediately.
What did the defendant tell you?
The defendant told me I needed to leave immediately.
What did you tell the defendant?
I told the defendant that the cashier knew I was going back to get the item and that my stuff was already at the register and I was going to be fast.
Did he say anything to you after that?
He told me that the store was closing and he was a security here, that he didn't care what the cashier said, I needed to leave.
Did he escort you to the cash register at this time?
No, I just proceeded to the cash register, and at that time is when I heard the defendant say under her breath that she was going to fix me.
How did you take that?
I was very offended and kind of scared at that point because I didn't know what she was going to do.
At this point, were you the only one in the store?
There were 2 other customers in the store at this time, but they were getting ready to walk out.
What happened when you got back to the checkout line?
I was once again confronted by the security guard at the shop hall who told me that I could not pay for my items and I needed to leave.
What was going through your mind at this time?
I was just really frustrated because I kept getting harassed by the security guard and over deodorant, which the cashier knew I was going back to get.
After being harassed, what did you do?
I turned to the security guard and told him I didn't know what your problem was because the cashier knew I was going back to get it and I'm here now.
Did Officer Lawrence allow you to finish your purchase?
No, Officer Lawrence told me that if I didn't leave immediately, she was going to lock me up.
Did you in any way physically attack the defendant after she told you that she was going to lock you up?
No, I didn't. At this point, the defendant was really close to my face and told me I needed to leave the store right now.
How were you feeling at this time?
At this point, I was really scared because the defendant was so close to my face that I didn't know what to do. I was kind of stuck in a rock and a hard place because the cashier knew I was going back to get the item and the defendant was harassing me continually.
As a result of your fear, did you do anything to seek help?
At that point, I pulled out my cell phone and called 911, which I told the defendant I was doing so.
What did you tell the 911 dispatcher?
I told the 911 dispatcher that I was being harassed by a security guard at the shop hall and I was fearful and I wanted them to send the police right away.
How did the security guard react to that?
Out of nowhere, the security guard just took me and threw me up against the conveyor belt.
Where were the other customers at this time?
They both had already walked out of the store and they both looked back worried because they seen what was going on and they were locked out from the inside.
What emotions were you feeling at this time?
I was really, really scared because I've never been handled like this before, so I was really fearful at this point.
And what were you thinking at this point?
All I kept thinking was if I could get the security guard off of me and stand up straight, I would be able to defend myself.
What happened when you tried to do this?
That's when the security guard smashed me into the glass case.
And what happened next?
At that point also, I just kept trying to regain my strength because I was being manhandled by the security guard at the shop hall. So at that point, I was more scared than I'd ever been before.
After the guard smashed you into the glass case, how did you physically feel?
I was in a lot of pain and I was screaming.
What happened when the police arrived?
When the police arrived, I was actually relieved at first because I thought they were going to take the handcuffs off of me and let me go home because I hadn't done anything wrong. But they came in and didn't even listen to anything I had to say.
Did they?
Yeah, they came in and all they did was listen to Officer Lawrence.
Were there a lot of, how many officers arrived on the scene?
There were 6 officers actually, which I thought was a little much, and plus Officer Lawrence, so 7 total.
So after the officers arrived, did the defendant talk to the police?
Did the defendant talk to the police?
Yes.
Yes, the defendant talked to the police, which the police would only listen to the defendant.
Did you get a chance to tell them your side of the story?
Not once.
After being arrested, did you try to tell them anything else?
I tried to tell him that my planner was left at the register and also that I was hurt and I needed to get to a hospital.
How did they act to that?
They could have cared less.
Where did they take you?
They took me to the hospital.
How long were you there?
To the police station, sorry.
How long were you there?
It felt like forever, but I think I was there for about 5.5 hours.
How were you treated?
I was actually treated like an animal. They put me in shackles, and when I was there, the entire police department just teased me the whole time.
Did you seek medical attention after being cleared from the police station?
Yes, I went right to the hospital.
Your Honor, may I approach the witness?
You may.
Could you please identify this document?
That is the police report.
Is it a fair and accurate description of the injuries that you have sustained?
This is the police report.
May I approach the witness, Your Honor?
May.
Is this a fair and accurate description of the document?
Yes.
Could you please read the chief complaints?
External bleeding from cuts and bruises, legs, arms, and face. Extreme discomfort in wrist, left shoulder, and right knee.
Thank you. Thank you. Your Honor, we move that Exhibit 4 be brought into evidence.
Any objection?
No, Your Honor.
The exhibit is admitted.
Thank you. Did the doctor give you anything to alleviate the pain?
The doctor gave me a brace for my wrist.
In addition to the hospital and doctor's treatment, did you seek treatment with anyone else?
My psychologist, Dr. Taylor.
Why?
Because ever since the incident, I had a lot of trouble sleeping and, I had a lot of discomfort around police officers and security guards, which I had never had before. And also, I had a lot of trouble concentrating in school, which actually a lot of times I had to stop myself from breaking down in class, so I left class a lot to go to the bathroom.
Miss Brooks, before this incident, did you ever have these problems?
Not these kind of problems, no.
No further questions for the witness, Your Honor.
Cross-examine.
Yes, Your Honor. All right, referring back to Exhibit 4, the hospital, can I approach the witness?
You may approach if you want to use this or use your own copy.
Yeah, she can use that one. It doesn't
Okay.
All right.
All right, can you read on there anywhere where you broke any bones? Or
No.
extremely damaged anything?
Just bruises and strains.
All right, now, just moving on. Did Dana Dureka ever give you permission to go back to the aisle?
Well, she told me it was an aisle one, so I just assumed that it was okay.
But she never directly told you to go back to the aisle.
No, she didn't.
All right, do you recall being told to leave the shop hall after closing time by Miss Lawrence?
Yes.
Did you follow her request?
Well, no, I didn't.
Yes or no?
No.
Where were your parents at this time?
They had left for Florida the morning before for my sister's wedding.
Why weren't you with your parents?
Because I had school the next day.
Isn't it true that you served an in-school suspension?
Objection, Your Honor. We motioned in limiting for this not to be brought into evidence.
And I've already ruled on that, counsel. It can be brought in, argued as it may bear on credibility, but not to show that the conduct on a prior occasion be directly portent of actions that were taken by this witness in this particular case, the plaintiff in this particular case. I'm sorry. You may proceed. The objection is overruled.
All right. So isn't it true that you served an in-school suspension for talking back to one of your teachers?
Objection, Your Honor. It goes back to the same thing you just said. This wasn't supposed to be brought in
I'm not.
unless of
I
impeachment.
didn't rule that way, counsel. I said that it could be brought in.
Yeah, I'm not trying to show a pattern of influences. I'm just asking. All right. So, yeah.
Yeah, I did, but the main reason was because I
All right.
didn't miss school.
Did you talk back to Officer Lawrence in the store?
I defended myself with verbally.
Matter of fact, didn't you yell at Officer Lawrence? Yes or no?
Yes, I did.
And when Officer Lawrence tried to arrest you, you pushed him off of you?
I was never told I was under arrest.
Well, when Officer Lawrence tried to detain you, you pushed him off of you, yes or no?
Correct in self-defense.
All right. So is it fair to say that you have problems with authority?
No, it isn't fair to say that.
All right. Then what do you call the situations that you've had with Officer Lawrence and your school not going to Florida?
I don't. Can you
No
rephrase
further.
the question?
Well, I have no further questions.
Okay.
Redirect.
No, Your Honor.
Step down. While you're next.
The plaintiff calls its second witness, Dana DeRacia, to the stand.
Please raise your right hand. Swear to abide by the rules of the 72nd District mock court trial.
Yes, I do.
And have a seat, please. State your name and spell your last name.
My name is Dana Drecha, spelled D-E-R-E-C-H-A.
You may proceed.
Mr. H, are you currently employed?
Yes, I am.
And where are you employed?
I work at the shop ball on the south side of town.
How long have you worked at this shop hall?
I've worked at the shop ball for 6 years.
And what's your position there?
I am the head cashier.
How long have you been the head cashier?
I've been the head cashier for 5 years. I was promoted after my first year because I'm such a hard worker.
And what was your position before being appointed a head cashier?
I was just a cashier.
Now, do you have a specific shift that you work at shop hall?
I work mainly afternoons and evenings at the shop hall,
Familiar with store policies?
of course.
Just a second, Your Honor. Permission to approach the witness, Your Honor.
Okay.
You recognize this document, Mr. H?
Yes, it is excerpts from the shop ball cashier superstore handbook.
Is it a fair and accurate representation of the manual you received upon your employment at the shop hall?
Yes, it is.
Now, if you would, could you please read the store policies regarding customer service?
All cashiers are expected to ensure shop ball customers get the best service possible. Our customers are our business. All shop bar customers are to be welcomed by friendly cashiers. All shop bar customers are to be treated with respect and treated fairly.
At this time, Your Honor, the plaintiff would move that this document be admitted as Exhibit Number 6.
Any objection?
No, Your Honor.
The exhibit may be admitted.
Thank you, Your Honor. Now, with respect to the incident in question, were you working on the night of October 26th, 2006?
Yes, I was. I was working the cash registers, and because business was kind of slow that day, I let most of the other cashiers go home early.
Now, if you recall, who was working with you that evening?
I recall Alex Camp, the store assistant manager, and I recall Officer Lawrence, store security.
Have you worked with Officer Lawrence before?
Yes, I have.
Okay. On the nights that you have worked with Officer Lawrence, what does he typically wear?
Normally, she typically wears a security guard uniform, and since we rarely have any problems at the shop hall, I've never seen her with any type of gun or weapon of any sort.
Now, let's see. Okay. Do you recall seeing my client that evening?
Yes, I do. Your client, whom I later found out was Evan Brooks, approached my cash register with a cart full of items and then realized that she had forgotten some deodorant.
Did you give her permission to get the deodorant?
I told her it was an aisle one.
So, what did she do once you had told her what aisle it was in?
She proceeded to go and get the deodorant and said, aisle one, I'll be back fast, I promise.
At this point, had the store doors been locked?
Yes, they had.
And how do you recall that?
Because after Miss Brooks ran to get her item, two other customers, a man and a woman, approached me to unlock the door and let them out of the store.
Did Miss Brooks return to your register?
Yes, she did.
Did she have the deodorant?
Yes, she did.
Did you ring up the items?
No, I didn't get a chance to because Officer Lawrence approached her in a very rude and aggressive way and told her that she needed to leave the store.
Okay. How did she react to that?
I saw the look on her face when she turned away from Officer Lawrence, and she looked really upset, and she proceeded to take out her cell phone.
Do you know whom she called?
Since she began telling the person on the other line that she was feeling threatened by a security guard and afraid that the security guard might do something to her, and from my perspective, she only dialed 3 numbers, I believe she called 911.
Did she tell the operator anything else?
No, she didn't get a chance to because Officer Lawrence pushed her on the conveyor belt and attempted to handcuff her, and then slammed her into a glass case full of soda.
Did anyone else witness this occur?
Yes, the 2 other customers that I had previously let out of the store were banging on the glass because they witnessed this horrific attack on Miss Brooks, and I just kept thinking this has to look so bad.
Had you informed the assistant manager, Officer Lawrence, about, giving Miss Brooks permission to go back and get the deodorant?
When Alex Camp finally came out from the back, he proceeded to dial 911 too. And I tried to explain to Officer Lawrence that I knew that Evan Brooks went back to get the deodorant, and I thought the entire situation was getting out of hand.
At any time, did you hear Officer Lawrence tell Miss Brooks that she was under arrest?
No.
Did the police arrive following the phone call?
Yes, they did, and I was shocked when they proceeded to arrest Miss Brooks. She did nothing to deserve such treatment from anyone.
Based upon your observations, your own personal observations, do you believe that Officer Lawrence had followed store policies?
No, he abused his power and was way out of
Objection
line.
that calls for an opinion.
It's the lay opinion of a store employee well-versed in all manners of store policy.
But she has not been qualified as an expert, therefore her opinion is irrelevant.
I move on, Your Honor.
All right, the objection is sustained. You may proceed.
Okay. Did you personally witness any physical injuries to my client following this scuffle?
Yes, after the attack, she had cuts on her wrist. She was complaining that they were hurting her, and she was hysterically sobbing. She was very distraught after this incident.
Nothing further from this witness, Your Honor.
Cross-examine.
Yes, Your Honor. You've been a cashier for 6 years now, is that correct?
Yes.
And you've been a head cashier for 5 of those years, is that right?
Yes.
On the night of October 26, 2006, you stated you were the only working cashier, is that correct?
Yes.
You also stated that you let most of the cashiers go home early, is that right?
Yes.
So were you the only one working cashier that night, or was there someone else there with you?
Besides Alex Camp, who was in the back, I was the only one working the cash registers.
Also on the night of October 26, you say it was close to closing time. How close was it?
When Miss Brooks went to get the deodorant,
Oh, right around closing time in your witness statement, right when all this stuff happened.
it was close to 10.
It's shop law procedure to lock the doors minutes before closing time, is that correct?
You said that way too fast. Can you please repeat it?
It's shop law procedure to lock the doors minutes before closing time, is that correct?
Yes, it is.
Were the doors unlocked when Evan Brooks entered the store?
When she entered it, obviously they were unlocked if she entered the store.
So the store was still open?
Yes.
You also say you zoned out. Could you please explain to the court what you meant by that?
Well, after Miss Brooks proceeded to go to get the deodorant, since there was few people in the store and I'd let the other 2 customers out, it's common to start thinking about other things while still paying attention to your job.
Which is more important to you, Mr. Ecca, shop all policies or ensuring that all shop all customers get the best service possible?
Can you please state that again?
Which is more important to you, shop all policies or ensuring that all shop all customers get the best service possible?
I would say that they're both equal.
You also say that Lawrence is acting very mean towards Evan Brooks, correct?
Yes, and rude.
And he did this when he got really close to Evan in the checkout aisle, correct?
When he approached her and told her she had to leave.
Was he being mean or was he just being stern? Or she?
No, he was being mean and rude.
Are you a licensed attorney or law enforcement official?
No, I'm a cashier.
But you do watch Law and Order?
times.
Is that the extent of your understanding of proper criminal procedure?
Objection, Your Honor. Calls for facts, not in evidence.
On which question?
The law and order question, I believe.
It states in her witness statement that the only criminal procedure she is aware of is watching Law and Order on the weekends. It says so right in her witness statement.
Thank you, Your Honor.
Well, the objection is overruled, but well, you may proceed.
Are you aware that Officer Lawrence has been a police officer for more than 6 years?
Yes.
And that in those 6 years, she has had more experience with proper police procedure than you have?
I don't know her life story, but I'm assuming since I'm a cashier, she'd know a little bit about the law more than me.
Then how would you know if Lawrence was out of line if you don't even know anything about criminal procedure?
Because you can tell when someone's attacking someone else.
You were the only one person in this incident that was written a reprimand, correct?
Yes, I was.
Is this reprimand going to block your promotion?
Most likely.
This very alleged incident that brings us here today was so horrendous and so horrible, yet you never once called for assistance?
Alex Camp came out and called for assistance.
Did you ever call for assistance?
No.
As a dedicated shop-out cashier, you have made a pledge that all shop-out customers get the best service possible. Do you believe Evan Brooks got this service?
No, she was attacked. I don't think that calls for best service.
No more questions, Your Honor.
You redirect.
Yeah, quickly, Your Honor. Mr. Racha, you do understand that you're under oath today, correct?
Yes, I do.
And you were written a reprimand as well, correct?
Yes, I was.
Objection. The question is leading.
It's given in prior testimony.
Still leading.
Well, the point is that it has already been brought up. The answer to the question has already been given. And I think really it's more in line of a question that leads to another question. So the objection is overruled. You may continue.
In testifying here today, having already received your punishment, is there anything for you to lose or gain by your estimation?
No.
Thank you. Nothing further, Your Honor.
Recross.
Not at this time, Your Honor.
All right, step down. Thank you. Call your next witness.
The plaintiff calls Dr. Whitney Taylor, Your Honor.
Please raise your right hand. You swear to abide by all of the rules of the 72nd District mock trial.
I do.
Have a seat, please. State your name and spell your last name.
Dr. Whitney Taylor, Taylor.
You may proceed.
Dr. Taylor, what is your occupation for the record?
I'm a psychologist.
Do you have a specialty in this field?
I usually deal with college-age youth or young adults.
How do you know Miss Brooks?
She's a patient of mine.
Are you testifying today with her permission?
Yes, I am.
When did you first treat Miss Brooks?
September 13th, 2006.
Is this before the incident that we're here for today?
Yes.
When you first examined Miss Brooks, what findings did you make?
That she was very bright and driven, but also insecure.
Why might she be insecure?
Well, the reasoning is because her father moved around a lot when she was a child, and she never had many friends because of it, and because she was often one of the top of her class and ridiculed for it.
Did you see Miss Brooks after the attack of October 26, 2006?
Yes, I did.
How long afterward?
6 days afterwards.
Did you notice anything unusual at that time?
She was significantly unhappy and seemed to be under a lot of stress.
Was her physical demeanor any different?
She was very sullen, withdrawn.
Was she able to tell you about this incident?
She had difficulty speaking about it, and then when she started to, she was crying.
When she was finally able to gain her composure, what did she tell you had happened that night?
Said she was assaulted by a security guard at the shop hall, and she was thrown around like a rag doll.
Is that a direct quote from her?
Yes, it is.
Did you note any injuries at that time?
Her wrists were visibly swollen and blue.
Did you personally see these?
Yes, I did.
Was Miss Brooks able to go about her everyday activities following this incident?
No, she had trouble sleeping, which led to problems during school, and she had to be excused from her classes to stop from breaking down emotionally.
In your professional opinion, will Miss Brooks suffer the effects of this incident temporarily?
It would be a long-lasting event in her mind.
What actions were taken to help her cope with this?
I recommended she saw her over doctor, and he prescribed Zoloft and sleeping medication.
Now, Zoloft, what is that for?
Antidepressant medicine.
Thank you. No more questions for this witness, Your Honor.
Cross-exam.
Evan Brooks is a patient of yours, correct?
Yes.
And you see her every week?
Yes.
Would you say that she has a few emotional problems?
That could be said.
Would you say that she's insecure?
Yes.
Would you say that she has problems adjusting to certain situations?
Yes.
Is she sensitive to her surroundings?
Yes.
Is she also sensitive to what people say and do?
Yes.
Does she react with hostility at any time?
At times.
Has she ever been disciplined for an act of hostility?
Objection, Your Honor. The discipline of that incident was not to be brought into evidence. The discipline was allowed, but it was not to show that she was hostile, Your Honor.
Well, I think that the jury will understand the prior ruling of the court that purpose for which the information may be used, and so the objection is overruled. You may continue.
Thank you, Your Honor.
Has she ever been disciplined for any acts of hostility?
Yes.
You've been treating Brooks for less than 6 months, correct?
Yes.
Do you know anything of her prior medical history?
I know what she's told me.
So you can really only be sure of any acts of hostility in the time you've treated her, correct?
Yes.
No further questions, Your Honor.
Redirect.
Yes, Your Honor. This hostility that you noted, does this occur in every incident?
No, it does not.
Does she need some, say, provocation in order to act hostilely towards someone?
Yes, she would.
Thank you. No more questions.
Recross.
Not at this time, Your Honor.
All right, you may step down. At this point, the defense, assuming that the plaintiff rests at this point.
We do, Your Honor.
All right. Defense, call first witness, please.
I would like to call Shannon Lawrence to the stand.
Please raise your right hand. You swear to abide by all the rules of the 72nd District mock trial.
I do.
Have a seat, please. State your name, spell your last name.
Lawrence, Lawrence.
You may proceed.
Please state your name for the court.
Shannon Lawrence,
Where do you live?
2727 29th Street.
Are you married?
Yes, I am.
Where did you go to college?
Superior City University.
Did you further educate yourself?
Yes, I did, in police work.
Where do you work?
I work at Clearwater Police Department and at Shopwell.
When do you usually work?
Usually I work from 7 a.m. to 4 p.m. at Clearwater Police Department doing patrol, and then at 7 p.m. to 11 p.m. at Shopwell as a security guard.
What was your work schedule on October 26th, 2006?
I had to do some overtime at the police department because they were short-handed, and I filled in for some people there. And then I went straight to Shapa.
What usually happens during your shift as a security guard?
I sit in the surveillance room from the time I get there till 9:30, and then I do a sweep about 10 o'clock.
Was there any difference in your sweep on October 26, 2006?
When I first started to sweep, there was a person walking down the aisle, which later was known as Evan Brooks.
Did you interact with Evan Brooks in any way?
I did. I walked up to the plaintiff and told him to discontinue shopping, that it was about closing time and should go to the register and check out.
Did you at first ask her to leave?
No, I didn't.
Did you ask Brooks to proceed to check out?
Yes, I did.
Did she ever listen to did she ever listen to your request to proceed to check out?
No, she didn't. She just sat there complaining that she thought it was ridiculous and kept on continuing going down the aisle looking for deodorant.
When did you ask Brooks to leave the store?
When it was closing time, sorry.
Did you do anything before you asked Brooks to leave the store?
I finished sweeping the aisles.
Did Brooks comply within any reasonable amount of time?
I don't believe so.
What did Brooks do after your instructions?
He continued going to the register and was still complaining.
Was there a conflict between you and Brooks?
Somewhat. A conflict.
What happened during this somewhat of a conflict?
He sat there yelling at me and arguing with me.
Did you ever do anything about her yelling at you?
I did. I kept on replying to him to leave the store, or I'd have to take actions.
Did you take any actions?
I did. I tried to enforce the law by restraining Lawrence and escorting him out of the store.
Did your attempts succeed?
No.
What did you do during your attempts?
At my attempts, I had to try to arrest him because he was fighting back so much.
How so?
By struggling and jerking, pushing.
How did you attempt to arrest Brooks?
I had to put him on a flat surface and arrest him.
Could I interrupt at the moment here? I think we're getting our genders confused here as to male, female of the witness, and I think that this witness is a female, of course, and the plaintiff in this case is a female, and so we probably ought to get that squared away. You may proceed.
Did you ever slam Brooks into a glass case?
No.
What actually happened?
When I had Brooks down on the conveyor belt, she jerked back, which then we both stumbled into the glass case.
Did Brooks knock you off balance?
Yes.
How were you able to keep a grip on her hands?
Grasping her hands, holding on to her wrists.
Did you have any specific methods?
What I was taught in the police department.
Thank you, Your Honor. No further questions.
All right. Cross-examination.
Yes, Your Honor. What hours do you work at the police department again?
7 a.m. to 4 p.m.
What hours do you work at the shop on?
7 to 11.
Do you recall the day of October 26, 2006?
Yes, I do.
Is it true that you worked from the police department at 7 a.m. until you had to go to your job at Shapa?
Yes.
So you worked more hours than usual?
Yes.
So working this many hours, you did not have time to change your uniform, correct? You worked the shift at the shop hall in your Clearwater Police Department uniform, correct?
Yes.
You also had your gun and your handcuffs, correct?
Yes.
Is it true that you leave the surveillance room sometime before 10 p.m.?
Yeah, about 9:30.
So if I understand your testimony, if you're in the store a minute after closing, the customers are instructed to leave the store?
Yes.
Who trained you at the shop hall?
Alex Camp.
Your manager instructs you to use force?
When necessary.
Are you familiar with the shop hall store 2005-2006 handbook? Security guard
Yes.
handbook? Yeah. May I approach the witness?
You may.
Could you please identify this document?
2005-2006 security guard handbook.
Is this a fair and accurate depiction of this document?
I would say so.
Could you please read Article 2, Section 3 only?
All shop hall customers must be welcomed by friendly security guards.
And then there's a second one right under it.
Oh, sorry. All shop hall customers are to be treated with respect and by security guards. Sorry.
Thank you. You were not treating her with respect or being friendly when you got in her face and confronted her, correct?
I did ask her to.
Correct? Yes or no?
I would say so, yes.
What time does the store close?
10 p.m.
You said that you gently restrained and physically escorted my client, Miss Brooks.
Yes.
Did you ever, at any time, tell Miss Brooks that she was under arrest?
No.
So in other words, my client could have thought that you were actually trying to hurt her.
It's possible, but I am a security guard.
But you had your police uniform on, with your gun and handcuffs, correct?
Yes.
So giving someone cuts and bruises and making them bleed is how you gently restrain or physically escort someone? Yes or no?
No.
That's what the evidence shows. Officer Lawrence, after the altercation, the police arrived, correct?
Yes.
7 officers plus you after making the 911 call.
Yes.
Did they ask you what happened?
Yes.
Did they ask Miss Brooks what happened?
No, not really.
They didn't. You said you have extra training. Do you know what that extra training was? The classes that you took?
Forensic science.
There are 6 of them. Do you know the 6 or no?
No.
No further questions, Your Honor.
You may step down, thank you. Call your next witness.
Is the defense cause Devin Rodriguez to the stand?
Please raise your right hand. Swear to abide by all the rules of the 72nd District Court mock trial.
State your name and spell your last name, please.
My name is Devin Rodriguez. Rodriguez been spelled R-O-D-I-G-U-E-Z.
You may proceed.
All right, would you please state your name for the record?
My name is Devin Rodriguez.
All right, what forms of education do you have?
I studied criminal justice at Superior City University and entered the police academy.
What is your current occupation?
Police chief for Clearwater Police Department.
How long have you been with the Clearwater Police Department?
I've been with them 16 years.
How long have you been the police chief of the Clearwater Police Department?
6 years.
What are your duties as the chief of police?
Well, it's basically the overall direction of all the police officers, and that includes training them.
Have any problems occurred during your 6 years as police chief?
About 2 years after I became chief, there was an increase of claims of police brutality.
Did you do anything to help police to community relations after these claims?
Yes, I helped create and personally teach the 4 classes required at our police department.
Can you tell me more about these classes, these courses?
Yeah, these classes are required for all street officers to help them become better at what they do.
All right, and how many courses are there?
And there's 4, 3 of which are required.
Can you give me a very brief description of what officers learn in those classes?
Yes, in the first class they learn about civil and criminal liability, and the second class they learn about authority and jurisdiction for use of force. In the third class they learn about proper arrest procedures. In the fourth class they learn about new skills to help resolve conflicts between citizens and officers.
Your Honor, at this time the defense moves to enter Chief Devin Rodriguez as an expert in the field of police procedure and community or police to community relationships.
Your Honor, would you allow a voir dire of this witness, or would you prefer that I wait for cross?
Voir dire is not allowed by rule, and it would be necessary for you to wait until cross-examination. I will allow the questioning as I will, however, wait on the ruling regarding whether he may be considered an expert witness or not until that time. That may govern how the answers will be allowed and which may be stricken at that time. I think that's one of the problems of the format that we have, frankly, but anyhow, you may proceed with your questioning and you may cover it on your cross-examination.
To cause no inconvenience, we have no objection to the expert status.
All right, you may proceed.
All right, did Officer Lawrence take these classes?
Yes, he was required to take 3 of the classes, and he chose to take the 4th optional class.
So why do officers such as Miss Lawrence have to take these classes after they were in college and just graduated from the police academy?
Well, because they're required by the department, and they help them become a better officer.
All right, how was Officer Lawrence as a student?
He was a very interested student. He was very concerned with the issues of how to deal with the different things in the classes.
Are there any tests or examinations that report the progress of your officers?
Yes, there are.
How did Officer Lawrence do on these tests?
He did very well. He was the top student in 2 of 4 classes.
All right. Can I have permission to approach opposing counsel with this exhibit?
May.
All right. Let the record reflect that I am showing the plaintiff, Shannon Lawrence, the Clearwater Police Department personal record form. It's Shannon Lawrence's personal record form. Can I please approach the witness with it?
May.
Do you recognize this?
Yes, I do.
What is it?
It's a personal record form for Shannon Lawrence.
All right. Were there any complaints about Officer Lawrence?
2 minor ones. There was no. They weren't serious enough to take disciplinary action.
All right. How was Officer Lawrence's performance?
It's very good. He's received mostly 1s and 2s, 1 being the best you can get.
And did he receive any awards?
Yeah, he received 3 awards.
Thank you. All right. At this time, I would like to offer what has been marked Exhibit 5 into evidence.
Any objection?
All right.
The exhibit is admitted.
Thank you, Your Honor. What did you learn about the incident in the chapel on the night of October 26, 2006?
I learned from talking to other officers and Officer Lawrence and from the police report that Evan Brooks was out of control and acting with rash behavior.
All right. In your expert opinion, did Officer Lawrence have the legal justification needed to arrest Evan Brooks?
Yes, he had all the legal justification because after several reasonable requests by Officer Lawrence, he did not leave the store.
All right. No more questions, Your Honor.
You may cross-examine.
Chief Rodriguez, would it be fair to say that you know Officer Lawrence fairly well?
Yes, I do.
What gender is Officer Lawrence?
Officer Lawrence is female.
Thank you. Are you, you say that you teach proper methods of what is and is not excessive force, correct?
Yes, I do.
And you also teach a legal update class, is that correct?
Yes, I do.
In that class, do you teach recent court cases?
Yeah, sure.
Are you familiar with the 6 factors considered in establishing excessive force that were determined in the case of Smith versus Clearwater, a 2001 decision?
I just have to refresh my memory.
I see. Would it be possible that known character of a suspect is one of those?
Yeah.
How about risk faced by an officer?
Like I said, you'd have to refresh my memory. I'm a very busy man.
I guess the following would be nature of offense, chance of escape, alternative method of arrest available, and size, strength, and weapon of the officer. Does that sound correct to you?
Somewhat, yeah.
Are you familiar with the case of Brown versus Clearwater, a 2002 decision?
Yes.
Would you please explain what happened in that case?
Again, you'd have to refresh my memory. I'm very busy. I have many things to deal with.
Did you not just say you're familiar with that case?
I remember
Objection,
it.
Your Honor. This is irrelevant. What is the case? This other case is irrelevant to this case.
I would like to establish that that these important cases in excessive force have not been, in fact, taught in his classes.
All right. The objection is overruled. I think that it is relevant. You may proceed.
Thank you, Your Honor. So, would it be possible that in this case, a security guard was found liable for excessive force after making verbal threat to a customer and then causing injuries during an attempted arrest?
I don't know about all that.
That is, in fact, well, isn't it true that you do teach recent court decisions, however?
Yes.
Well, how recent does a court case need to be?
It doesn't really matter.
Isn't it true that 4 years ago, the amount of excessive force complaints in your department grew so out of hand that the mayor himself approached you about the creation of classes?
The mayor did approach me, but it was just a slight increase. It wasn't that large.
Chief Rodriguez, do human beings make mistakes?
Yeah.
Would it be logical to conclude that police officers are human beings?
Yeah.
So, do police officers make mistakes sometimes then, yes or no?
They may.
Concerning Officer Lawrence, did you go to the same college as he did?
Yes, I did.
Excuse me, she did?
Yes, I did.
Who recruited Officer Lawrence? Would you say that may afford you a little bit of bias, yes or no?
I wouldn't say that.
On the topic of October 26, 2006, were you at the scene of the incident?
No, I was not.
How many officers were at that scene?
7.
I'd like to draw the court's attention to stipulation number 1, agreed upon by both parties, where it specifically states that 8 officers plus Officer Lawrence were at the scene, Your Honor. Well, wouldn't logic tell you that 8 of your well-trained officers, as well as Officer Lawrence, might be a little out of hand for restraining one teenager?
Well, there were several people that called the police, so there was plenty sent there because they didn't know exactly what was going on.
Now, did the officers there witness the altercation?
Not all of them.
When they arrived at the scene, did they interview Miss Brooks to see what her side of the story was?
I don't think they did.
I'd like to refer the court's attention to stipulation number 11, where it specifically states that they did not. So the only side of the story heard before Miss Brooks was arrested was that of Officer Lawrence, the defendant in this case.
Yes.
Thank you. No more questions.
I have a
Redirect.
I would like to refer back to Exhibit 5. Can I approach him?
You may.
All right. How long ago was the last complaint issued to Officer Lawrence?
4 years ago.
When were his last 2 awards issued to him?
2 and 3 years ago.
What were they for? Can you read them for us?
The one in 2003 was recognition for best tweet. There's one in 2001 of outstanding relationship with the community. And there was one in 2004 of recognition for work with community educational initiatives.
All right. So, in your expert opinion, is it possible for an officer to change, or better yet, learn the proper way of handling things?
Yes.
Do you think this happened to Officer Lawrence?
Yes. Officer Lawrence has become an outstanding officer.
All right, no further questions, Your Honor.
Recross, Your Honor?
You may.
You say there are many awards in his record. How many complaints are there?
2.
How many of those were for excessive force?
2.
No more questions.
You may step down, thank you.
Thank you, Your Honor.
Okay, call your next witness.
The defense calls Alex Camp to the stand.
Please raise your right hand. Swear to abide by all the rules of the 72nd District mock trial.
I do.
Okay, please have a seat. State your name and spell your last name.
Alex Camp, ALEXCAMP.
You may proceed.
Where is it you work at?
Shop all.
What is your position there?
Assistant manager.
Does Shannon Lawrence work for you?
Yes.
What kind of person is Lawrence?
Hardworking, consistent, reliable, just a great guy all around.
Who was it that hired Lawrence?
I did.
Do you regret hiring Lawrence?
No.
Why not?
Again, we're getting involved with a gender problem.
I apologize, Your Honor.
She is always on time, she's reliable, and she always gives 100% of her effort.
What were you doing on the night of October 26, 2006?
I was in my office going over some sales figures for the week.
What time was it?
It was just a few minutes after 10.
And how can you be so sure of this?
I looked at my watch.
What happened next?
I heard some loud noises coming from the floor.
What was Lawrence doing?
Lawrence was trying to restrain a customer.
What did you notice next?
I noticed that the customer was using vulgarity against one of my employees and that he was resisting restrainment.
And what happened after that?
Objection, Your Honor. Calls for a narrative.
I don't think it really calls for a narrative. He was asking him what happened, in effect, what happened next, and that's an allowable question. The objection is overruled. You may continue.
Brooks continued to resist Officer Lawrence's restrainment and pushed off the conveyor belt and knocked Officer Lawrence into the glass case.
Did you write a written reprimand?
Yes.
And who was it for?
Dana Dureka.
Why did you write that?
She blatantly disobeyed policy, and she should have told the customer that he was not allowed to go back to the aisle.
Do you feel sorry at all for Evan Brooks?
No, I don't. He disobeyed my store's policies and did not listen to my employees.
Thank you. No more questions, Your Honor.
Cross, Your Honor.
Cross-examination,
Yes, Your Honor.
Mr. Tinker.
Now, in your statement, you claim to have instructed your security guards to use force when making their demands of the customer. Is that true?
When necessary.
Okay. That's a direct contradiction of the provisions provided within the security guard handbook, is it not? One moment, Your Honor. Well, anyways, I'd like to refer back to the security guard handbook, admitted as exhibit number 7. In the customer service policy, it states that all security guards are expected to ensure Shopall customers get the best service possible. Our customers are our business. Article number 2, section 3 also cites all Shopall customers must be welcomed by friendly security guards. Now, would you classify that as friendly?
Well, Brooks was not a customer. He was a trespasser.
Oh, was he?
Yes.
No, those are the charges here that were dropped, by the way. Now, honestly, I wouldn't think that it would be fair, friendly, warm, in the slightest, to slam somebody onto a conveyor belt.
He was resisting arrest, and he was a trespasser in my store after closing time.
Once again, to prior testimony, I'm going to say that not once did Officer Lawrence claim that and did tell Brooks that she was under arrest. Not once. So, yes. Now, moving on, isn't it true that you arrived sometime after the inception of this scuffle between my client and Officer Lawrence?
A few minutes.
Okay, so then you hadn't witnessed any sort of a provocation on the part of Brooks, then, had you?
All I witnessed was Brooks assaulting one of my employees.
Assault, you said? Yep. Okay. You heard my client cry out for help, correct? Yes or no?
Yes.
And you had seen the defendant pin my client's hands behind her back, did you not?
I saw him restrain him.
You are in... Yes, I will refer your attention. It's a her, by the way. And you are in charge of the store at that time. You had been at that time.
Correct.
And yet, in such a position of authority, you did nothing to defuse the situation at hand, save to dial 911?
I assume Lawrence had it under control.
Okay. Nothing further from this witness, Judge.
No directions, no redirect, Your Honor.
All right. You may step down.
Thank you.
At this time, we will have summations by both counsel, first by Nicole Glass. I don't know whether you need to at this time. Do you wish to bifurcate your presentation by giving a direct and then a rebuttal?
Yes, Your Honor. We request 1 minute for rebuttal.
All right. So that will be confined to 4 minutes for you.
Gentlemen of the jury, this case is simply a matter of which testimony is fact and which is just opinion. Let's pay attention to the facts in this case. The facts are that a young woman simply wanted to finish her shopping. 1 stick of deodorant. A minute, maybe 2. Let me ask you a question. Is this really an offense considered violent enough to justify the beating that Miss Brooks sustained? It was just simply a matter of an overzealous officer who'd worked over 15 hours that day, becoming flustered with his job and wanting to get home earlier. As soon as Miss Brooks showed any indifference to his authority, he lost his cool. At that point, he threw her down on a conveyor belt, hurled her through a glass cave, and caused her many cuts and bruises, as well as emotional trauma. There's no excuse for a well-trained officer to act this way. She had permission from another employee to go back to that aisle, an item that would take no time at all in comparison to how long his day was. No time at all. The age of Miss Brooks is the differentiating factor in this case. She was labeled as a possible shoplifter and trespasser because teenagers in the past had done that in that store. There was no reason for her to be categorized in such a manner. Officer Lawrence severely overreacted and does not want to take the blame for his own actions. The police officer, when they arrived, what did they see? They simply saw a fellow officer making a decision to restrain someone. Did Miss Brooks get to say what her side of the story was? No. They automatically presumed that she was a criminal. When even so, Officer Lawrence could have been the one to blame. They did nothing to determine that. She did nothing to provoke the wild, uncontrolled actions of this police officer on a power trip. Please, gentlemen, let's make this ruling in favor of Brooks. I'm sure you'll be familiar with the civil code stating who is responsible for the actions of Officer Lawrence. That would be the police department. Please, avenge this flagrant violation of human rights.
Ms. Tienda?
Your Honor and gentlemen of the jury, I would like to thank you all for your time and attention. I know you've all considered the facts very thoroughly, and I appreciate all the time you've given up to do so. Today, the plaintiff has the burden of proof, and they have failed to meet this burden beyond a preponderance of the evidence. The first item the plaintiffs have failed to prove is battery. Battery is an intentional act that causes harmful or offensive bodily contact without legal justification. While yes, there was an intentional act that did cause bodily contact, there was in fact legal justification. When Brooks became hostile and threatening, Shannon Lawrence was in every way legally justified when using enough force to apprehend her. The second item the plaintiffs have failed to prove is false arrest. False arrest is when a person detains or restrains another without consent and without legal justification. Again, while there was restraint without consent, there was legal justification. Brooks dug herself in, becoming a trespasser by refusing to leave, and bound by duty, Shannon Lawrence restrained Brooks in the manner of her training. The third and final item the plaintiff has failed to prove is intentional infliction of emotional distress. Intentional infliction of emotional distress is intentionally or recklessly engaging in extreme and outrageous conduct that intends to cause and causes severe emotional distress to another. Shannon Lawrence and the respected police of the Clearwater Police Department in no way intentionally or recklessly engaged in any extreme or outrageous conduct. The conduct that occurred was never intended to cause, nor did it cause, extreme or severe emotional distress. All conduct was according to standard police procedure and accepted as such. Today you have heard the testimony of several witnesses. And today you've heard all the proof you need to find that Shannon Lawrence is not guilty and is actually just a mother providing for her family. In fact, you have heard all the proof you need to see that Evan Brooks is just looking for a way out of a hole she dug herself into. You've heard from Shannon Lawrence, an upstanding police officer and a wonderful mother. She works hard to provide for her children, working 2 jobs and still making time for them. She's an incredible worker who loves what she does for a living, putting all of her effort into her work. She was proceeding with a normal shift as a security guard until Evan Brooks decided to cause chaos. When Brooks blatantly refused, continuing her shopping and yelling at her in a threatening manner, she was legally justified in both an arrest and the touching that comes from apprehending a suspect. Devin Rodriguez will tell you, or has told you, that Shannon Lawrence is an incredibly willing officer. She's taken all of the required courses and all of the courses available to her. She's been at the top of her class in every class she's taken. And Devin Rodriguez has also told you that the officers performed as they had been trained to do so. Alex Camp, assistant manager at Shopall, has told you that Shannon Lawrence is his most valuable security guard and that she followed store policy in every way. Evan Brooks, the alleged victim in this case, told you herself that she yelled at Shannon Lawrence and ignored her and did not obey any of her requests. Dana Dureka told you that she was daydreaming and that she was issued a written reprimand. And Dr. Whitney Taylor told you himself that Evan Brooks has emotional issues, authority issues, and he knows nothing, well, only what she told him of her prior medical history. Gentlemen of the jury, obviously you cannot find Shannon Lawrence guilty based off these facts. Evan Brooks simply dug herself in a hole and cannot seem to find any other way out of it. I ask you today to deny Brooks the opportunity of an escape from what should be her responsibility. I ask that you find Shannon Lawrence a hardworking mother, not guilty. Thank you for your time and attention.
All right, you may proceed with your rebuttal.
Thank you, Your Honor. Gentlemen of the jury, you've been told several times now in this case that Ms. Brooks has the burden of proof. However, it is in fact the job of a police officer and also that of a security guard to prove that they are not in fact using excessive force. She has the burden of proof. Ms. Brooks was never told that she was under arrest. Not once. She was never told that Officer Lawrence was a police officer. She simply thought that she was a security guard bullying. There was no reason for Officer Lawrence to act as excessively as he did. Officer Lawrence is in the wrong. Let's find her responsible for that. Thank you.
All right, the case is now concluded, and
Your Honor, excuse me, I didn't mean to interrupt, but may I approach the bench?
You may, with whoever from the opposing counsel.
I was not able to bring this up when it happened, but upon direct examination of Alex King, the plaintiff team objected to one of my questions, and the person objecting was not the person who was going to be crossing. Stand is a violation of the rules and procedures for trial.
Your Honor, that objection was not upheld anyway.
It wasn't, but the, as I understand it, when you're making your objection in the beginning, the person who was to You're right, I understand that. And the only thing that I can do, I can't make any ruling at this point because you didn't bring it up at that time. If it was a situation where you couldn't have brought it up at that time, some reason why, some good reason why something could be done about it. But and perhaps I should have recognized that myself. But nonetheless, I don't think that it's anything that's causing any great difficulty in the case because the objection was overruled anyway.
So, you don't want me to speak for me? I don't
know. At this time, as I understand it, we are to huddle and discuss the case further.
All rise. Be seated. All rise.
Thank you. Please be seated. All right, at this time, actually, I think I turned my timesheet in, and I don't know that I've got people's names down. I'm going to give a bit of a critique. And one of the things that I do here is to kind of let you know, give you an overall presentation and what I thought of each of your performances. The first is that I'm speaking to the plaintiff's team at this point. You needed to flesh out your case much, much better than you did. You got to understand that the people that are over here in a jury box have never heard of your case. They don't know one item about your case. So you have to get the facts of that case out to them as quickly, concisely as you can, and as thoroughly as you can. And when I went back into the jury room and I asked them, I said, if you were sitting as a jury, would you know what this case is about totally? And the answer is no. You need to flesh that out significantly more than you did. And some of my comments are going to be rather hit and miss because of random. One of the other things that comes very quickly to mind is we got to the end of the case and there was a discussion about guilt and innocence. This is a civil case. There is a distinct difference between a civil case and a criminal case. A criminal case is where you discuss guilt and innocence. Guilt and innocence has nothing to do in this case. The question is, was the person, was a tort committed? Were there damages? And was the causation of those damages shown? And so you're asking not to find not guilty. You're asking them to find that there was no, either that there was no tort or there was no damage or there was no causation or whatever your position would be on those items. But forget about the guilt and innocence stuff. One of the things that happened was that, and you recognize that you are a team. So your witnesses actually are a part of your team. Plaintiff's witnesses, I thought, did a little bit better job in the sense, and I'm not criticizing necessarily individuals here, but perhaps it might be a team criticism. Plaintiff's witnesses were I mean, they gave advocative testimony, really. I mean, there were words that were used by the horrendous conduct by this officer and stuff like that. When you're a defense counsel in that situation, you need to be on your feet and objecting to the witness's characterization of the conduct. And I waited for that to happen, and it didn't happen. And I'm not picking necessarily on individuals when I go through this, but Mr. Hagel, your opening statement, you need to be aware of all of the facts in this case, and you read your opening statement. Do not do that. As soon as you start reading to a jury, you're going to lose them. You need to maintain eye contact. You need to know your facts inside, outside, upside, sideways, every which direction. You need to be able to get up there and speak almost extemporaneously. One of the worst things you can do is to write out your opening statement. You need to, you might write it out, but then do an outline so that you can refer to it as you're going along and still be able to maintain eye contact with the with the jury. There I go, doing just exactly what I was going to say that you shouldn't be doing, is saying you did, a couple of other people did. When you're pausing, probably one of the worst things you can do as a public speaker, and you are a public speaker up here. I will say this, I say this to a lot of lawyers, and a lot of lawyers, maybe some of them in this room, are tired of hearing me say it, but I ask lawyers from time to time, what is your job in a courtroom? And I get all kinds of answers, never get the right answer unless they've heard my speech before. But the answer is you're a salesman. You're trying to sell a product to that jury, and you want to sell your product before the other side sells that product to the jury. So therefore, you have to describe your product, and in a plaintiff's case, you have to show the injury, or you have to show the violation of the law, you have to show injury, and you have to show causation, those three things. I never did hear a number. In a plaintiff's case, it would seem to me that you ought to be in there at the very end and say, I think that you ought to award this plaintiff $30,000, $100,000, whatever the number you think. Likewise, you should be saying this person should recover nothing, and here's why. I think I've said enough at this point. I could make some other comments, but Mr. Bankson.
Judge Nicholson makes good points. Listen to them. I'd like to say great job, both teams, and a whole lot of hard work and preparation, and thank you. And it's a pleasure for me to sit here and listen to you guys. I'm going to say to you, slow down. Slow down, guys. Judge Nicholson points out that we can't follow. It's hard to follow. Slow down. And don't be afraid to object. Don't be afraid to assert yourself. Get the gender thing down. I think let's get that down.
Amen.
It's a matter of thinking on your feet, but let's get it straight. The next time that your 10:30 trial, Evan might be a guy. Well, if Evan's a guy next time, call him a guy. And Evan's a gal, call her a gal. Thank you very much. It's a pleasure listening to you guys.
I thought it was good too. It's obvious you guys have all put in a lot of hard work. And I think the first thing you need to do is know your material. You need to know these facts, you need to know the exhibits, and you need to know them inside and out. And so you can almost recite them. But as Judge Nicholson says, what you've got to do is package that knowledge together and present it to the jury. Because what you're here to do is persuade them. And the best of you, the best of what you did was not just to recite the knowledge, but put it together in a way that it's going to persuade you of what you need to persuade us as to what you need to persuade us for. So, for example, you decide you've got certain cross-examination questions you want to ask. When you come up to the podium, you're not there just to ask those questions. You're there to make certain points, and you use those questions to make those points. So if you ask a question and you get the wrong answer, it doesn't mean you necessarily just move on to the next question. You've got to go up there with what point you want to establish and ask questions until you get there. Unless it's clear you're not going to get there, then you probably stop. But the same thing's true with your direct examination. I thought you had a pretty good sequence of laying out events, but remember that you're not just asking those questions. What you're trying to do is get the answers out there to the jury in a way that's going to persuade them. And the persuasion isn't just by setting up the logic of this is what you have to prove to do battery, to show battery case, this is what you have to prove to show intentional infliction of emotional distress. You want to persuade them of the logic of all of that, how the evidence fits within that, but you also persuade by emotion. And if you get witnesses up there acting, not just knowing the facts, but making them their own, so they're the real people out there and acting like that person, it's going to persuade people. You got to persuade them by emotion as well as just logic. And I think the best of what you did went along those ways, went along those lines. But anyway, good job, and the more you do it, the more you practice, the better you're going to get. And not just practice by thinking about the case and writing out questions, by actually performing it, saying your opening statements and your closing statements, your cross to the mirror or to your parents or to your brothers and sisters, even though they wouldn't want it, they don't want to hear it, you make them listen to it. And the more you do it, the better you're going to get at it.
I'd just like to say I thought everyone did a very nice job. A couple of things I did notice on the negatives. Just remember when you're up to the microphones here at the podium, you can breathe, guys. You don't have to hold your breath. Breathe, relax. I concur with everything that Judge Nicholson and my colleagues here have said, so I'm not going to reiterate that. But overall, I thought a job well done. As the day goes on, it'll become easier for you, and have fun. Thank you.
Okay, I'm going to add a couple of more things here. The first is that one of the things that you absolutely have to get over is being intimidated by this guy up here in the black robe, or a gal up here in the black robe. You know, one of the ways that the attorneys will tell you sometimes that witnesses have a terrible time feeling intimidated by the judge. You guys don't be intimidated by the judge. The thing that you need to do is you need to get to the point of where the judge is just another person up there, although the judge is controlling the case, just another person up there. No big deal. One of the ways of thinking of it is, and you have to be able to do it without laughing, but one of the ways is to think of the judge and look right past that black robe and think of the judge sitting there in his underwear. And not a pretty sight. But you have to get past that black robe problem. And once you get past that, your confidence will build. And that's really what you need to have, is you need to have confidence up there that, darn it, you got a case. And you're presenting this case to these people as a jury, or to the judge, or whatever, and your case is better than their case, and vice versa. Your case is better than their case, and you have to show by statements, questions, and answers to those questions that that's true. So, as John indicated, you've got to paint a picture with words and questions. And you've got to have a product at the very end. Witnesses, speak up. We had a problem with a couple of the witnesses. Your voice is not very big, but you still need to project, because this is still a team effort, and witnesses are part of the team. So you need to be as prepared as you possibly can in all respects. Good luck in the future, and thank you. Good job.